Good afternoon and welcome to today's presentation, Sandy Hook, Liability and Special Education. Before we begin our presentation today, I would like to take a few moments to go over some housekeeping items. We will be recording this webinar, and this webinar is CLE approved, and we'll be asking that you enter a passcode for CLE credit a few times throughout the presentation. In today's webinar, Mr. Paddock and Mr. Yeager will discuss lack of accurate understanding of federal law regarding special education, safety issues, a management issue, and poor management of students, the real problem. To give you a little background about our presenter, Brad Paddock, he is a veteran teacher, special educator, and school administrator, working in both private and public residential and educational institutions over the past 34 years. He has many years of experience as a first responder with numerous qualifications and certifications, including New York State Fire Instructor for the Office of Fire Prevention and Control. He is an appointed member of the staff of the New York State Division of Homeland Security and Emergency Services, as well as Office of Fire Prevention and Control. Dale Yeager has a career in forensics spanning 22 years. He has advanced training at the Federal Law Enforcement Training Center from 2005 to 2008. Mr. Yeager's research work on violence has been published in the FBI Law Enforcement Bulletin and Profiling Violent Crimes by Dr. Ronald Holmes. Mr. Yeager is a frequent expert with media outlets, including a featured episode of Forensic Files. Mr. Yeager is an instructor for the Newman University Criminal Justice Program. For those of our attendees who require a code word for tracking purposes, the code word for today is school. During the presentation, we will take short breaks, and during that time, we'll ask that you enter this code into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you're applying for CLE credit, you must log onto your computer as yourself. Also, please remember to complete the survey that will appear to the right of your screen at the end of the presentation. As a provider of CLE credits, we are required to have supportive information that you have attended, and in many states the survey is required. CLE certificates will be provided within 24 to 48 hours via email. CLE credit is also only available to those who have attended the live presentation. You are not eligible to receive CLE credit if you view this presentation on demand. Also, the PowerPoint slides can be downloaded from the resource list on the left of your screen. Mr. Paddock and Mr. Yeager welcome your questions. Please use the Q&A widget to submit your questions throughout the presentation. We will take intermittent breaks so that our presenters can respond. Thank you all again for attending today, and Brad and Dale, the presentation is now turned over to the both of you.
Hello, everyone. This is Dale Yeager. I'm glad that you have attended this very special presentation because this is a critical issue. Whether you are an attorney who has a legal action pending against a school system, an LEA or a private school, or if you are an attorney who is defending a school system as part of a board, this is very, very important. One thing that I wanted to share that's not in my bio, but Brad's is quite extensive, is that I did my teaching when I was in college, my student teaching for juniors and seniors in a high school in Pennsylvania. So one of the things that we are very adamant about at Seraph is that you cannot teach what you have never done. And one of the things that's critically important in talking about this issue of liability and special education is that you have to have had that experience. It's not just the experience that Brad and I have had, with Brad working for me out in the schools throughout the U.S. and Canada, seeing what's going on with special ed, but you've had to have done it. This gives you a unique perspective. And Brad's experience in education has been extensive with special education, special needs children. And so that's very, very important. But as we go through this, we're here to help you answer questions. If my throat sounds froggy, I'm fighting a cold, so I apologize for that in advance. So let's talk about the high liability issues in the management of special needs children. So when we're looking at students, we have to talk about the facts. And one of the problems is that we have decision-making going on with school boards and administrators and special ed directors in schools, and they don't have the facts. They're not keeping up on the data. This is an issue we're going to address even further in this presentation. But if you look here at the facts, and we've sourced everything, you can look this up on the internet. In 2009, the U.S. Department of Education estimated that over the next 5 years, 60% of all K-12 students will be special needs. Well, they have met that number. In fact, that number varies depending on the school, obviously, and the school population, but when you average it out, 60% have some type of special need as defined by federal IDEA special education law. So we are at that point, and it is not stopping, and that's why this type of program is so vitally important. Fastest growing student disability is autism. There's a lot of debate about autism. I don't want to get into the scientific aspect of it, but suffice it to say there is an environmental, behavioral piece to this related to parents, and so this is not going to stop. This is going to continue to grow as a problem. The good news is that the newer research that's being done, University of Minnesota and at UCLA, shows that children who have low spectrum autism can do just fine. In fact, Asperger's syndrome, which is the most common form of autism, is something that Dan Aykroyd, the actor, has had his entire life, and he's done perfectly fine. So I think that sometimes we need to make sure that we understand that just because a student has a special need does not mean that they cannot succeed in life and have a wonderful, meaningful life and certainly get a great education. Juveniles account for 1/3 of all sex offenders. Female juveniles are the fastest growing group of sex offenders. And you say, well, why in the world would you bring that up? Well, because back over 10 years ago, the Department of Education, which does a lot of work with the U.S. Justice Department, found that most sex assault cases, most cases of student-to-student sex assault were happening with special needs students, whether in the classroom, in the school, or on some form of transportation. And so sex crime by students is a critical issue. And what's really concerning all of us in forensics is that we are seeing over the last 4 to 5 years this incredible increase among juvenile females in sex offense. And so this is something that really needs to be addressed, whether, again, you are a plaintiff attorney with action against the school system, or if you are defending the school system as an attorney, you need to know these issues. And you need to ask yourself, well, are the staff, are the management team of that school system, are they current on this information? Have they had the proper training, or are we all assuming that they've had that? Because I will tell you, 30,000 schools that we have worked in, most are not being kept up to date on what's really going on. In fact, in our experience, and we're out on the ground in schools in numerous states every week, and we're finding that special ed directors are woefully behind in their federal updates, and we're going to talk more about that later. But I wanted to talk about those statistics to get them planted into your head as we go through this. The lack of accurate understanding of federal law regarding special ed. I am amazed and disgusted. I don't think that's too strong of a word to use when I encounter professionals in a school environment, an LEA, a school district, who don't have the current updates on IDEA. And the updates they do have, they really don't understand it, but yet they're dealing with special needs students. I know that this may come as a shock to some of you, but it is a common problem, and we see it constantly. And it's something that is really disturbing, because if you're not current on federal law, not only are you putting your school system at risk from a liability and a legal perspective, but children are not being served. One of those problems occurred at Sandy Hook with Adam Lanza. There's a lot of myth and a lot of misinformation about what went on up there. And we wrote a report. It's our 4th report for Congress. We write school safety reports for Congress starting in 2000. And we were asked, this is for the Senate Judiciary Committee, we were asked to give them an understanding of what really happened at Sandy Hook. And as we dug deep into the Sandy Hook story, we started to realize that there was more than enough evidence that the school system and the school administrators, excuse me, had violated IDEA. And so this was a problem because had they followed IDEA, and this is based on the research that we did for the report, I believe, and I've done this now for a quarter of a century, I can safely say as a professional that that shooting would not have happened for various reasons. Adam Lanza would have been looked at with a microscope. They would have understood what his problem really was because, contrary to news reports, no one really knew what he was diagnosed with. There was no social worker looking in on the home, understanding the dynamic of that house. And so really people dropped the ball, but I would say that they did more than drop the ball. They violated federal law. It is possible, based on the evidence that we pulled together, that 7 different occasions of violation of that federal law. And so this is important to understand, that people do get hurt in the process of not following IDEA. There is a specific correlation between that and school safety issues. So procedural safeguards. This is something that, again, we find a lot of special ed teachers and special ed directors do not understand as it relates to the law. You know, what are the procedural safeguards that you have to put in place to make sure that you are not violating it and that children are being served? So I'm going to turn it over to Brad for a few moments and let him kind of talk about his own experience in seeing these holes in the procedural process and where that brings up a liability. I'll explain that after Brad talks about the issue of procedural safeguards. Brad?
Thanks, Dale. And welcome, everybody. I'm glad to be here. From my experience, and that is primarily in public school that I'm going to speak to now, the training, particularly training in maintaining your knowledge and updates of IDEA, is not really provided on a regular basis. Not only is it not provided to special ed staff, we'll find that the regular ed staff is woefully unaware of IDEA and their responsibilities when students with special needs, students with IEPs, are participating in their classrooms. And what happens is elements of a student's IEP are disregarded. It causes low performance or allows low performance on the part of the student. And the only folks that are going to address those failings would be those folks who are not well trained. So a lot of times the regular ed teacher, possibly the special ed teacher, are not even aware of the laws that they're breaking, of the elements of IDEA that they are not addressing. So there isn't really... And the
problem, and Brad, I would like to interject, one of the problems that we see in working with schools is they have no procedures in place to, on a regular basis, do their updates. I've actually sat recently with a special ed director of a major school system that most of you would know, that at least the city. And I asked her, I said, because the board had asked me to talk to her, I said, when was the last time you saw updates from the federal government, reviewed the updates for IDEA? And she goes, oh, it's been like 2 years ago. Well, there were updates in September of last year, only a few months ago. And because there was no process that she had put into place to update herself, she wasn't updating the staff. I think that's some of what you're talking about, Brad.
Exactly. And what I wanted to just add to that is that with everything that's happening with curriculum, with testing, with Common Core, the time frame for staff development, test preparation, devising and implementing modifications, accommodations, extra time, we're trying to squeeze that into the same roughly 6-hour school day that we were using 10 years ago, 20 years ago, 30 years ago. So the management of this staff development, the management of the practice of special ed, whether you one-to-one or whether you're running an inclusion program in regular ed, is critical. We have very little time that's allocated, and what we're seeing is the kinds of statistics that Dale shared with you at the outset. And until we get a handle on training our managers better, training our teachers better, those statistics stand very little chance of improvement.
And that, Brad, brings up our third point, which is local school policies that violate state and federal laws. One of the biggest problems, if you're an attorney who is representing a student against the school system or an LEA, the problem is that sometimes state law is in conflict with federal law, because most states, through their Department of Education, have some type of rules and regulations governing special needs students. And a good example of this conflict is the state of New Jersey. About 60% of all the schools that we work with in the U.S. are in New Jersey. And one of the things that happened was several years ago, a law was passed called HIB, Harassment, Intimidation, Bullying Law. The problem with the law is it violates federal law, and it's caused a conflict down in D.C. because the problem with this HIB law is they took adult civil rights law and applied it to children and adolescents. Well, that's a problem right there, because it's in conflict with federal laws that were established by actually a case that was decided by the Supreme Court back in the late 1980s. And basically, that case said that children do not enjoy the same civil rights as adults in the same manner, because otherwise we cannot protect them from harm. Child can't decide, I'm going to jump off a bridge. Kind of the same thing with the First Amendment. You can't just say anything you feel like if it causes harm. So the problem is that when you're doing a case and you're presenting a case to the court system, if you're doing it to a federal court as a civil rights case, then that's different. But if you're doing it to anything that's not a federal entity, a state court or a local court, the problem is that there can be conflict between the state law and the federal law, and this can create a problem. Those of you who are listening to this that are attorneys that defend school systems or even insurance groups, this is something you have to work out. You have to figure out, how do you protect your school system, your school, from liability issues with this conflict between state and federal law? This is a serious issue. I mean, we could talk for hours just about that issue alone. But these are all things to consider on either side of the spectrum legally. All of these issues that we're presenting here, including this conflict between state and federal law. So I guess we have questions now, Emily. Is Emily there?
Could all the attendees type the passcode into the Q&A before we begin? Okay, our first question is, what about a child that the district refuses to assess for a disability?
Well, that's a violation of IDEA, and it's actually a felony. It is actually a federal felony. So if they refuse to do that, first of all, the rule is very clear that it has to be in writing. Brad, you want to talk more about the process to ask for an evaluation of a student?
Well, that can come from either the parent's request, or it can come from school staff. But in any event, the request, and on the part of the parent, the consent for evaluation has to be acted upon within a 30-day time frame on the part of the school district. There's no getting around doing that. So the initial evaluation needs to be, the IEP committee needs to meet and make a determination as to the evaluation. The real critical part of a successful evaluation process is the cooperation between the school and the persons in position of parent for the child. The greater that degree of cooperation, the unilaterally, the better the process is going to go.
Any other questions?
How do I decide for my client whether I should file a federal case?
Well, first you have to look at the student and what the school did or did not do in relationship to federal law. So you're going to have to do that anyway, whether you file it locally or federally. You're still going to have to look at that because federal trumps local law and state law, but there could be a conflict in the court system on that. But if you're making a decision of how to file that case, you really need to have an assessment done of your case as it relates to federal IDEA law to determine do you have grounds. If you don't have grounds, then you have to look at violations of existing school board policy within that school system. That also needs to be looked at. And then state Department of Education regulations, which are law in the state. So you have to assess the case. It's called a case assessment. We do a lot of them actually to determine where the suit should be filed, or in the case of defending schools, which we do, taking a look at what's coming at them with a student. Did they do all the right things? Where's the proof that they covered all their bases on a federal basis in the event that they're getting a lawsuit against them on a federal level? We do both. But you have to assess those laws and the case details of that case specifically.
Okay, and what are some of the challenges school districts face that result in failing to implement a school's individualized education program?
Okay.
Well, I can address that.
Go ahead, Brad.
A little bit. I think one of the primary challenges that we face from a district perspective is the education of the school board members and also some administrators in terms of the resources that are necessary to implement programs for certain students. I'll just give you an off-the-cuff example. We may have a group of students who require a 6-1-1 staffing ratio in the classroom. 6 students, a special ed teacher, and a special ed teaching assistant. To the average citizen, that sounds like an awful lot of staff for a small group of students. And the problem is, if you're on a school board and you're balancing the needs of the taxpayer to pay and the costs of providing a program, there comes a time when you almost dismiss that 6-1-1 as being something we can't afford. When the fact is, you really can't afford not to, because by failing to provide for the needs of a special ed child, first of all, there's the child and their family and the child's ability to access the public education and the child's ability to benefit from it. But as we have been talking about, the liabilities for not following through with the identification, the assessment, the development of the appropriate program, and then the implementation of that program and measurement of its impact can be far more costly than sitting down and in a very concise way managing your resources appropriately in the first place, following IDEA, following your state's interpretation of IDEA, and making sure that your school policies are in line with both the state and the federal regulations.
Any other questions?
Yes. There was a recent situation in Texas where a student wrote a book about using violence against his fellow classmates. He was removed from school for 2 weeks by his parents for evaluation and then allowed back at school. The parents are now protesting, and they're also pulling their children out of school. What do you think should be done about this? Should the child be allowed back in school, or should he be expelled?
Well, the question, this has happened before. This is not the first time. First question is that student special needs? Because if the student has special needs, there is a specific process in place under IDEA for disciplining that student. And it's not much different because there have been a lot of modifications to IDEA when it comes to disciplining students. But the first question it has to be asked is, does the student have special needs? If the student has special needs, then there is a procedure that must be followed under federal law in the process of disciplining, even investigating what the student did. If they're not special needs, well, the issue is one of terroristic threat, because, you know, while everybody enjoys the idea of freedom of expression, the problem is that when we're dealing with adolescents, when we're dealing with children, you know, freedom of expression can sometimes fall under the line of making a terroristic threat. So the question is, did the story mention specific students? How old was the student? There's a lot of factors that have to be assessed to determine whether the school did the right thing or not. There's no simple answer to this. There's a lot of variables that you would have to know. And this is where attorneys get into trouble. I will tell you from doing this for a long time, plaintiffs' attorneys get into trouble because they're really not evaluating all the details as it relates to state and federal law. And then attorneys who are defending school systems, they're really not understanding or really assessing sometimes whether the administration is is keeping up to date on federal law, and if their process that they're going through meets the federal standard. There's really details here that have to be looked at. I wish I could give you a simple answer, but there's too much information that's missing from the story, and I don't know that specific case. I apologize.
Okay,
any other questions?
Yes. Does the IEP committee have a duty to reevaluate an SPED student after it knows the child was raped at a school event?
Brad, you want to talk about that?
Could you repeat the question? I missed the last part of it.
Sure. Does the IEP committee have a duty to reevaluate an SPED student after it knows the child was raped at a school event?
My understanding is that if a crime's been committed, doesn't that fall under Title IX, the sex crime piece?
I believe so. I
believe it does. Yeah, I think there's new additions to Title IX, and some of that is a part of IDEA because it's part of ADA, the Americans with Disabilities Act. So when a crime has been committed, or there's an accusation of a crime, which would affect the child's individual education plan, I believe that, I really don't know, and I have to find that out and get back to you, but I believe they're required to go back and do a reevaluation because obviously that would affect the process of the IEP. Is that what you understand, Brad?
It is, and I just wanted to say that the one would assume, which we shouldn't do very often, but one would assume that there is a significant trauma to the student, which is will affect not only physical, but potentially the mental health of the student. And anytime that you have a significant change, it's always wise for the team to reconvene, and particularly in the case of a crisis like this, to make sure that the IEP continues to be in line with the student's needs. And
by the way, whoever asked that question, there's a much bigger issue here, which is the portal-to-portal law. Almost all 50 states in the United States have a portal-to-portal law. I don't know any that don't. And basically what that means is that you as a school system, as an LEA, you are responsible for that student from the door of their home back to the door of their home. So another big question that needs to be asked from a liability perspective is, how in the world did this happen at a school-sponsored event? Where was security? Where was the security plan? Where was the monitoring going on? I mean, we've done cases like that before where everyone's standing around in a huddle and no one's doing their job. So there's a whole other piece to this, which is which, depending on the age of that student, actually falls under the Child Welfare Act in that state. Because if you're not protecting those children, you have two levels. You have the portal-to-portal law, which is an educational law in the state. Then you have the Child Welfare Act. And both of those play a factor in the issue of a lack of security and monitoring at an event. And you can't. And for those of you who are saying right now, well, you can't prevent everything, Dale, I'm going to tell you right now, in forensics, we find that statement appalling. Because I will tell you that there is research out there that was done back in the 90s by the Justice Department that found that majority of all crimes could be prevented. And they could be prevented by better decision-making, by monitoring, primarily monitoring and management. So, schools have a responsibility to professionally manage their events. So that's something else to throw in there as an issue of this particular story. So.
And does the Child Welfare Act speak to the functional equivalent age of children?
It does, absolutely. Because you have, in the Child Welfare Act and the various pieces of that, age is defined, and each state has a different age, but even within the Child Welfare Act, you have the piece related to, you have the piece related to when a child can be arrested for a crime. Generally, that's up to the age of, most states, up to the age of about 8 or 9. 10, prepubescence changes some of the laws. Then you have the teen years. Well, that varies because the age of consent law, which I never understood, and I'm a federal trainer on sex crime investigation. I've never understood how states would pass laws that allowed teenagers to have sex with adults. But the thing is, sometimes there is an allowance of age in the age of consent. So you have to analyze all of that. All of that aspect of the Child Welfare Act has to be analyzed to the specific data of that case. So yeah, I mean, it factors in based on age. There's always age segmenting in those laws. But again, they vary from state to state. So.
Okay, those are all the questions we have. So if you could continue on with the presentation, that'd be great.
Thank you, Emily. All right, next, safety issues, a management issue. So some of you may know the name Dr. Peter Drucker. So if you are familiar with Dr. Peter Drucker, those of you who are not, the reason why we have the term administrators, the term CEO, CFO, COO, is because of Dr. Drucker. When he came to the United States in the 1930s, he invented, for the whole world, modern management practice. And because he did a lot of his work with nonprofits and municipalities, the effect of his genius, if I may say so, affected the way we see today in the last 20 years how schools are managed, how they're structured. And one of the things that he said was, we manage what we can measure. So I'm going to say that one more time. We manage what we can measure. One of the problems we find in school systems is that they have no measuring tool, no formal measuring process to determine whether they're doing all the right things. And if you're an attorney who has a lawsuit pending or active against the school system, this is something you need to be looking at, is what is their formal process, their formal ruler of management. One of the things that's interesting is the U.S. Department of Education, when you are a school entity and you apply for federal grants, one of the first things they ask you for is your master schedule. And Brad, you will agree with me that that is the key document in any school, correct?
Correct.
Because the master schedule will actually tell an educated person who understands education management whether you know what you're doing or not, and whether your schools are effectively operated. And so the master schedule becomes part of the assessment of a lawsuit for us is analyzing that master schedule, analyzing the formal process of keeping track of what's going on within that school system. And that plays a part in special education staff. We're generally not trained in emergency management of special needs students. Now that might be shocking to some of you, but it doesn't shock us. We find that emergency management training, usually done by the local fire department or police department, doesn't, because they know nothing about IDEA, they don't know anything about special education, they don't include that. Well, I will tell you from personal experience, and Brad will tell you from personal experience, that in an emergency, special needs students act very aggressively sometimes, or sometimes they just go into a fetal position and won't move. And you have to factor into your emergency plan the idea of getting them out of the building. And it is not easy because it requires you to speak to their unconscious mind. It requires a special kind of training to do that. Otherwise, you are in for a lot of problems. 20 years ago, the issue for emergency management in schools was getting the student out who's in the electric wheelchair that weighs 400 pounds. Well, we're way past that now. Now we have students who will either get aggressive during an emergency because of their special need, or they will become so frightened they'll just put themselves in a corner and not move. And if you're a parent and you've had a small child, you know, your son or daughter, go into a fetal position, and even though they only weigh 30 pounds, trying to get them off the floor, it feels like they weigh 100. And so this is where there's a major failure by schools in not updating their training to include special needs students. And by the way, special ed staff are only part of who needs to be trained in this area. Everybody in the school has to know how to help the special needs, the special education teachers during an emergency. Now, Brad, I call him my Swiss Army knife because he's been an administrator, he's been a special ed teacher and instructor and director, but he's also a state and federal fire rescue trainer and has been a fire chief, so he has a unique perspective on this. Why don't you share briefly, Brad, this issue of emergency management of special needs children?
One of the first areas you want to start with, and Dale mentioned, we've been in a lot of schools, and I can tell you emergency management of students in general has been an issue in a number of places. But when we start with a special needs student, that needs to be a question that we're asking if the student is involved in an IEP process, how do they respond? You know, we have our typical, and we've all been through the school fire drill. The bell goes off, and like a bunch of lambs, we line up and we follow one of two paths out of the building. It's a fairly mindless exercise. We're required to do it in New York anyway. I think we have to do it 12 times in a year with very little thought. Now, for those types of students that Dale has mentioned, whether it's the student in a wheelchair or it's a student who has a very excessive reaction to the loud alarms or the sudden change in routine, we need to plan for that, and you need to be realistic, creative. Now, one of the things that we talk about in the district that I worked in is what do we do with a student on the third floor because we can't use the elevator, and it's unsafe and unwise to have staff grab a hold of the wheelchair and just take them down the stairway. And there were issues with respect to the union. There are issues with respect to just the physicality involved in that kind of an exercise. Think for a minute in terms of creative response. If you've ever been in a nursing home or a hospital, when the fire alarm goes off, do they move everybody off the floor? No. Doors close. We evaluate where the emergency is and make a determination as to who, if anybody, needs to be relocated. Now that
and Brad, the reason why I wanted you to share that with the participants in this seminar is if you've listened to what Brad has said for the last few minutes, you start to get a clear picture, whether you're a plaintiff attorney or defense attorney, you're getting a clear picture that this is a complicated issue and that schools can't just sit down around a table in August, go over their emergency plans, say, oh, this looks pretty good, maybe we should add this, maybe we should add that. There needs to be a professional analysis done, and that's not getting done. And by law, most states require that to be done at the start of the new school year, and schools are not meeting that standard. So again, if you're an attorney who's representing a student, this is a weakness in schools, is a violation of their state standards for an emergency plan and what they need to be doing at the beginning of the new school year. And if you're an attorney who represents a school board, you need to be talking about this issue to your school board members and saying, we need to really do an evaluation of our emergency management process to see where the gaps are, because otherwise we're talking about major litigation. We're also talking about serious injury. Ultimately, we're talking about human beings getting injured here. But emergency plans are lacking. That's a whole other issue. Forget about that emergency management for special needs students is an issue. Most emergency plans are lacking. It's interesting when you look at emergency plans like we do on a weekly basis of schools all over the United States, and you just shake your head and wonder who put this together. It's a little bit of this, a little bit of that. It's a patchwork quilt of good ideas, bad ideas, and old ideas that don't even work. And so part of the problem is that instead of digging down and spending the time to really design an emergency plan that is specific to the schools in their district or specific to that, in a private school setting, that specific private school, they basically take an emergency plan from some other school, they cannibalize it, which is a nice way of saying they do very little editing to it, slap their name on it, and go on their merry way. And then they're shocked when they get sued or when an incident happens and there's a failure. Sandy Hook is a good example of this. Sandy Hook, the school itself in the Newtown school system, had no way, the people in the office had no way of hitting a code on their phone system to call for a lockdown. The ladies in the office were, the people in the office were pinned down by gunfire, couldn't reach the mic, which was on, by the way, the PA system was on. No lockdown was ever called for these classes. And what happened was that they didn't have it set up on their phone system, which takes no time at all, to dial a code and get a tone sent out so that everybody was alerted. By the way, after Columbine, when we started doing our work for the Senate Judiciary Committee in the White House, one of the things we saw was within 2 to 3 years, most of the school systems in the United States, both public and private, had already done the tone, programmed the tone into their phone system. Here was a very wealthy school system in Connecticut that had not done that, and Columbine happened in 99, so you're talking about 12 years later, it still hadn't done that. So this is part of the problem that we're discussing today. Policy updates. There you have to understand what are the new policies that are going on, federally or statewide that you need to put into your emergency plan. Again, they're not reviewing the updates on a federal level. So generally, they're not reviewing the updates on a state or federal level when it comes to emergency management. And so this is where these emergency plans and policies are failing to meet the real life reality of every day in that school or that school system. And this is a common problem we see all the time. You know, in every state in the United States, there's a state Homeland Security, Homeland Security Division, something like that. And they're there, and they work with schools. They have resources available, but they tell me all the time, very few schools will contact us. A lot of them don't even know we exist. It's that kind of a situation. So this is a serious management issue. And I know that that's not a common word that you see in legal actions, but management is the key, because management is about people managing people. And the failure of management, most of the time, in my experience, is the cause for crime or accident, not equipment failures. Mostly it's human failure of being lazy or being unprofessional. I know that sounds harsh, but that's what I've seen. And Brad has seen the same thing in his career. So let's dig deep into this now. Excuse me. So poor management of students, the real problem. The IEP issue. So Brad, can you explain in simple terms behavioral manifestation determination, please?
Well, it has to do with what disciplinary measures and timeframes in particular, because schools typically use a suspension or removal from a classroom as part of their disciplinary action. So behavioral manifestation is just answer the question, was the student's behavior, which violated a rule of the school, a manifestation or caused by or part of his handicapping condition? If it is part of his handicapping condition, then that creates activity or necessity of activity on the part of the committee to take a look at the student's IEP to see if it was followed, if the IEP is, if something has changed, does the IEP continue to address that student's handicapping condition? On the other hand, if the student engages in a behavior, again, violates a school code, and it's determined that the behavior is not related to the student's handicapping condition, then the school has the same latitude with respect to disciplinary action as they would if the student was not somebody with an IEP.
And by the way, Brad, something real quickly I want to insert. For those attorneys who represent school boards or represent school systems, there's a powerful question that you can ask when a lawsuit is filed, and you're sitting there with the opposing counsel, and you're talking about this specific issue of BMD. Ask this question. Well, how do you know, what proof do you have that it was not a cognitive decision on the part of the student to act or do this behavior? Because that's really what you're talking about. When you know cognitive, meaning that it was a decision that the student made out of their conscious mind to lie, steal, hit, punch, whatever. And so this is where this whole issue of the behavioral manifestation determination becomes complicated, because it clashes many times between psychiatry and psychology. They clash on this issue. And this is something where schools kind of give in, and they shouldn't give in, because they need to ask that important question. Well, what proof do you have that it wasn't cognitive, that it wasn't a decision of their conscious mind to do that action? And that's what you're talking about. A lot of times, because school systems do not understand this issue, or sometimes attorneys who represent these school systems have not been properly briefed on IDEA, they're not understanding the right questions to ask, especially in depositions. And so, or in these meetings. And so it's very important to think about that issue in a broader perspective. I'm sorry, Brian, go ahead. I just wanted to throw that in.
So in the bottom line here is whether or not the behavior is related. So that manifestation meeting is really important, as Dale is pointing out. And again, it's critical for the staff to be aware of the laws on this issue, because time frames become very important in terms of how long a student can be removed from a program, whether or not the student is considered to be a student with a disability, particularly in cases where the student has not yet been labeled. And another factor that plays into removal from the classroom is parental consent. There's a 10-day limit in terms of how long or how much time a student with a disability can be out of his program before it's considered a change of program.
And we're going to actually talk about that, Brad, in a moment here. That whole issue of parents. You know, the information. Go ahead. I'm sorry.
What I wanted to point out there was that the parent consent can extend the limit, essentially, if the parent agrees that the child should remain home for a few days, whatever the situation may be. However, if there isn't parent agreement, again, you really need to know those limits and the contingencies that are built into the law.
Now, the other issue is the information disconnect. You know, when you're an attorney who has a action pending against a school system or a school, this is something that you need to understand. What is the communication like between the special ed director, the administrator, the principal, the teacher, the teachers, the special ed segment of the school board? Where is there an information disconnect? And most times you're going to find that to be true. If you're an attorney who represents a school or a school board, you need to deal with this issue. You need to deal with this issue with your board and say, we need to have proper communication systems in place to know what's going on, and that information is passed on legally, but effectively between all those entities. But that brings us down to 4 assessments. So physical disability versus personality disorder. This is something that drives me crazy all the time. I'm a forensic profiler. I teach criminal psychology. So it's a little different than the therapy that you would go to, you know, as a family member, married couple would go to. We look at people for criminal behavior and negative behavior, obviously. But there is a distinction in the law between a physical disability and a personality disorder. And many personality disorders are not classified as a disease or a disability under IDEA. And so sometimes, many times, you have people that should not be doing evaluations, who are not trained in this, doing evaluations of children and giving them, slapping a label on them that is not based on fact. And this is something you need to dig into and look at. You know, well, where's the proof that this child has this condition? Adam Lands is a great example of that. His assessment that was done by his mother wasn't done. It's a shady medical procedure at best, medical evaluation at best, and no one knows what he had. And I will tell you that he may or may not have had the conditions that the parents were saying, but the problem is that nobody knew. In fact, he was looking it up on the internet to find out what his own problems were. Parents and disability assessments. You will find this is a huge problem. You know, not my child. My child doesn't have this problem. You will find it among various types of people, various types of parents. You will find parents who are defensive, who are very wealthy and educated because they don't want to think that their child has some kind of learning disability, since me and my husband and I have both had master's degrees. How is that possible? You have racial minority parents who have a very difficult time with this sometimes if they are working class or low income. We find this a lot. We're all adults here, and we're going to talk as adults. We see this constantly. We see also this problem among parents who are single parents, where the father's left, or the mother in many cases now, has left, single parent at home, and they really don't, they have a very uncomfortable with the idea of having a child with a disability because someone who's a pediatrician has not done their job. So this is an issue, this is a factor, no matter what kind of attorney you are, whether you're on the defense side or the plaintiff side, you need to understand this issue of parents and whether they are actively involved or is it a roller coaster with the school district. Yes, I want you to evaluate. No, I don't. I've seen that many, many times, and so has Brad. Quite a problem. So we'll go to questions now, Emily. I see our time is coming down here.
Okay, and could all the attendees please type the passcode into the Q&A once again? The first question is emergency management training not taught at the undergraduate or graduate level?
Oh, no, not at all. Brad, you would agree with me on that. You're talking about for teachers for education degrees?
Yes.
Is that what they're talking about? No. No, there's very, very little of that even discussed. Go ahead, Brad.
Well, the big issue there is each district, each building is very, very different. And the population of the buildings, the physical layouts, the climate of the building, that all plays into how you write your emergency management plan and how you implement it.
But as far as teachers, Brad and I went to college. We were education majors, but we weren't. There's very little discussed about emergencies in an educational degree.
Correct.
Yeah, it might be a passing discussion, but it is not talked about. It's interesting because now, in the last probably 10 to 12 years, well, probably 10 years, you really now, when you get an education degree, it has to be a double degree in special education because otherwise it's just not relevant anymore. So when I was going to college, I think we talked about special needs for 3 hours one time, and now it is a key element, obviously, of your undergraduate degree. But as far as emergency management, no, not an issue. Not discussed, sadly. Any other questions, Emily?
And what is being done to improve emergency planning in schools?
Brad?
Well, various states have created legislation, New York being one of them with the Safe Schools Act, to require the schools to have a planning process to address all of the facets of emergency management, including training. Locally, your school boards, some school boards have embraced those ideas. They have encouraged and supported a climate of and culture of safety within the school. They provide opportunities for practice. They actually create their own local plan rather than slapping their name on a boilerplate document that they pulled off the internet. So the efforts are out there. Fortunately, the incidence of things like fires and fatalities from fires in schools are very, very low. And I say that's fortunate because good for us. We're not killing ourselves and our children in schools due to fire. The downside of that is nobody believes it's going to happen here. So in a short answer to the question, legislation is requiring schools to plan. But when we go back to Mr. Drucker and measuring what gets done, and what gets done gets measured, the measurement is weak. And unfortunately,
the problem is that state law states that in most states you have to sit down before the school year and assess your emergency plan and your safety plan. Those are two different animals. And you have to make revisions accordingly. Well, if you're an attorney and you're doing your discovery, and this is part of the problem too, is if you're suing a school or a school system, you have to understand what you need to list on that discovery to get the documents necessary. Because a lot of times we see attorneys missing key documents. One of the things you want to look at is show me all the revisions for your emergency plan over the last 5 years, and you will quickly get a response where they don't want to turn that over because there have been no revision. That's a very common problem. Everybody got together, had coffee one morning, said, "Oh, I think it's okay," and did no assessment. No understanding what the problems were. Because an emergency is also an angry parent coming in the door and threatening a teacher or a principal. Emergencies are not just floods, they're not just fire, they're a mixture of things. They're also crime that can affect a large number of people and students, so that's important too. Emily, you have any other questions for us?
Yes. What influences outside the IEP process impact a school's interest in meeting the needs of a student with an IEP?
I'm sorry, say that again?
What influences outside the IEP process impact a school's interest in meeting the needs of a student with an IEP?
Well, again, that's related to the ability or the interest of administrators and board members to become educated about the special education programs within their district, which should be reflective of directly the variety of needs of students who have been identified as students with disabilities, and whether or not they are aware and are compelled to support the success of those students.
Well, I think too, Brad, with the question, now that I'm thinking about it, it's about outside influences that would influence a school to do an IEP. I think that's, if I understand the question correctly. A lot of times that's lawsuits. A lot of times it's investigations by state departments of education, or most recently, the U.S. Department of Education is on a tear across the United States investigating over the last about 2 years, very aggressively investigating schools for violations of children's civil rights. And so I'm down in D.C. probably once a month, once every 5 weeks, meeting with DOE people, because some of it you can't just get off the internet. You have to go meet with them. And they are adamant about this issue. And so the special needs, the IDEA, how IEPs are handled, all of that is being looked at, and people are being indicted. People are, school board members, special ed directors, principals. They are on the warpath when it comes to this issue of violation of children's civil rights. And so a lot of times that will cause a school system to start taking seriously the need for an evaluation. I mean, that's one of the things that prompts it too. So, because we're seeing a lot of that recently. They just show up one day with a knock-knock warrant, show us your records, and they're doing it quite a bit from DC and from state agencies too. So, any other questions, Emily?
Okay. Has any state passed legislation permitting the arming of faculty as an emergency protection?
I think it's been raised in states, but I don't think it's actually happened. And you're talking about armed as far as firearms.
Yes.
Am I understanding the question? Okay. Here's the problem. The problem is, for 40 years now, we have these wonderful, wonderful men and women who are police officers who are specially trained in the federal COPS program, and they are school resource officers, SROs. This program's been around for a long time, and it's a great program because it's federally funded, and it allows you to have a police officer who understands school environments, and then you turn that officer back over to the local police department for the summer, and they cover shifts for people that are on vacation, or they do bike patrols, depending on how large the community is. It's a great program, but a lot of people will not do it. They want to arm the staff. Well, that takes a lot of training. There's a great deal of liability in that. When they have this program available to them, but they don't use it. But a lot of times they don't even know about SROs. A lot of school boards don't even understand the process. So states have brought it up as bills after Sandy Hook, but I don't know of anybody that passed it. I do know that overseas it's very common for certain principals and administrators to carry pistols. That has been the case for a long time in South Korea. It is the case in Sweden, also in Austria and Germany. It's not talked about much, but it is done around the world in other countries. But here, I don't know of any laws that were passed after Sandy Hook for that purpose.
The school districts in New York, as I understand it, do retain the ability to permit otherwise licensed or police licensed carriers. The local school board can make that decision to have an armed person within the school.
But the one thing, Brad, I wanted to bring up to all the attorneys listening, and please hear me, it is illegal under federal law to disarm a police officer of any type while they are in uniform. So if they're on duty, your school board cannot, and I've had to deal with this on numerous occasions, where school boards have said, well, you police officer, you have to hand over your firearm when you come into the school. That is illegal. You cannot do that. It is a federal law, and most states have a law regarding that also. You can't disarm police officers or SROs, and this was a common practice back after Columbine when people were adding SROs. You're not allowed to do that, and that's something that is very important to understand. So anyway, wanted to add that.
Okay, those questions that we have. So we'll continue on with the CLE information. This webinar is eligible for CLE credit in California, Illinois, Minnesota, Missouri, New Jersey, Pennsylvania, and Texas. To ensure that you receive your CLE credit, please complete the survey at the end of the presentation. This is a reminder that CLE certificates will be provided within 24 to 48 hours via email. In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and document management solutions, free interactive webinars, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Brad Paddock and Dale Yeager for their time and effort in creating this presentation. If you would like to speak with Brad or Dale, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. This is a reminder that we will be sending out a link tomorrow with the archive recording. The archive recording will also be posted in the Knowledge Center on TASA's website. If you have any questions or comments, please email Carol Kowaleski. Thank you all again for attending, and have a great day, everyone.
Thank you, everyone.
It was a pleasure.